Welcome to today's Bipartisan Policy Center webinar, the Electoral Count Act, Conspiracies, Controversies, and Consequences. My name is Matthew Weil, and I direct the Elections Project at EPC. America's fragile election certification process became a vector of misinformation and real-life violence after the 2020 election and exploded into the national conversation on January 6, 2021. But the risks around the more than century-old Electoral Count Act were well known to constitutional and legal scholars well before 2020. The problem is, how the states and federal government interact on federal elections is complex and messy. The good news is that Congress is focusing on the ECA today, and here's what we know. Senators Susan Collins and Joe Manchin are leading a bipartisan effort to update the ECA, and Manchin says it should be a top priority along with funding the government. A bipartisan gang of senators is actively looking at discrete issues that might make it into any agreement. And these include ECA, protecting election officials, voting practices and rights, the Election Assistance Commission, and presidential transitions. The bad news is that all of those issues I just mentioned are very difficult and not well understood, and we hope to change that today. We are joined by Derek T. Muller, professor of law at the University of Iowa College of Law. He's a nationally recognized scholar in the field of election law, whose research focuses on the role of states in the administration of federal elections, the constitutional contours of voting rights and election administration, the limits of judicial power in the domain of elections and the Electoral College. He has published more than 24 academic works, and his op-eds have appeared in the New York Times, the Los Angeles Times, and the Wall Street Journal. He has testified before Congress, and he's a contributor at the Election Law blog. Welcome, Professor Muller. We are also joined by Richard Pildes, professor of constitutional law at New York University School of Law. He is one of the nation's leading scholars on constitutional law and a specialist in the legal issues concerning democracy. He's a former law clerk to Justice Thurgood Marshall and has been elected into the American Academy of Arts and Sciences and the American Law Institute. He's also received recognition as a Guggenheim Fellow and a Carnegie Scholar. As a lawyer, Professor Pildes has successfully argued voting rights and election law cases before the United States Supreme Court and courts of appeals, and he's a well-known public commentator, writing frequently for the New York Times and Washington Post. Welcome, Professor Pildes. And this panel will be moderated by Lara Brown, professor and director of the Graduate School of Political Management at the George Washington University. Dr. Brown is a distinguished writer and dedicated scholar about the American presidency and political system. She's a frequent presence in the media, appearing on dozens of television and radio programs, and serves as an expert on national elections and candidate strategies, political scandals, and presidential leadership for numerous print publications. She has also written op-eds for the New York Times, the Washington Post, Politico, and numerous other outlets. Dr. Brown, the panel is yours.
Thank you so much, Matthew. It is a delight to be here. I am really excited to moderate this panel today with such distinguished scholars, and I want to thank the Bipartisan Policy Center for all of the work that you do to bring together thoughtful individuals having serious conversations about really difficult and complex subjects. So I hope today will be something of an enlightenment for those who are tuning in. We have a lot of issues to discuss and even some rabbit holes to perhaps delve down. I thought I would begin this program really by just kind of giving an overview or a reminder about how it is that our presidential elections are supposed to work in terms of what the Constitution says and what the 12th Amendment specifies. So as you may well be aware, right, the Constitution says that each state must select essentially a manner by which they choose their presidential electors. So it is true that what happens is that the states are given the authority from the Constitution to come up with the method of presidential elector selection. Now, by the early 1800s, most of our states chose that method to be a statewide popular vote, that they would allocate their electors on the basis of a winner-take-all election. We are still in a situation where Maine and Nebraska are the exceptions, and they do that by allocating their electors by district. We then, as we sort of move through American historical time, passed a Presidential Election Day Act, which did establish the first Tuesday after the first Monday in November as the date on which the states would hold those popular elections. It's on that date that voters are in fact choosing which partisan slate will cast electors for that state later in the balloting. So I think one of the things that a lot of people are always confused about is they say, how am I not really voting for the president? You are actually voting for the partisan slate of electors who have really told their party that they are bound to vote for that presidential candidate. That's a separate issue, another fraught issue. Faithless electors are a famous kind of conversation point for people. But as we move forward, those electors then are in fact, once that popular vote has been certified and the appropriate electors are determined by the states, then what happens is that slate of electors meets in their respective state on the first Monday after the second Wednesday in December. They then cast their ballot and transmit those to Washington. Then what we know is that on January 6th, there is a joint session of Congress that the vice president presides over. And in that joint session, the vice president is tasked with counting those transmitted ballots and ascertaining the majority winners of both the presidential and vice presidential balloting. Then we move forward a couple more weeks, and on January 20th at noon, the new president and vice president are sworn into office, and there's a peaceful transition of power. That's how it has worked for many, many elections. It's how it still worked this last presidential election, though there was obviously controversy about not only what happened on January 6th and the insurrection that we saw in the Capitol and the attempt to prevent that counting of the certified state ballots, but there were also other activities that happened in December when the electors met. There were individuals from the unchosen slate of electors who actually did meet and cast what are essentially or alleged to be fraudulent ballots. So with that, what I can say is there's a lot of ambiguity in what should be a really, I would say, kind of uncontroversial process. And I think we are now in a place where the problems that we see are about the ambiguities and the vague language that exists in Article 2, the 12th Amendment, the Electoral Count Act, and even to a certain extent, the Presidential Election Day Act. So with all of that kind of laying out, what I want to do now is turn to our two incredible scholars and ask them sort of, what do you think is the biggest problem with the process that we sort of have articulated and that we typically follow, and those laws and precedents on the books? And what do you think matters most as there is this conversation about reforming the Electoral Count Act with a bipartisan group in Congress? So let me first hand this over to Professor Pildes. Please do join us with your thoughts.
Thanks very much, first of all, to the Bipartisan Policy Center. I agree with the comment that the Bipartisan Policy Center does incredibly important work, and it's so difficult in our day and age to have institutions that support bipartisan work, and so I really value the BPC, and I'm glad to have the opportunity to speak here with Derek about these issues. The way I would frame this is we're now in a moment of sort of pervasive institutional distrust about the legitimacy and the fairness of our election process. The distrust is based on different reasons for different sides, but what it means is that when it comes to the presidential election process, we now have concerns about whether Congress will handle its assigned role in the legally appropriate way. We have concerns about what may happen in the states and whether state legislatures or perhaps secretaries of state or governors might end up for partisan advantage seeking reasons distorting a fair count. And so we have institutional distrust at kind of every level of the process. So when you ask what the biggest task facing Electoral Count Act reform is, I think I would say it's dealing with that institutional distrust that runs up and down the system at this point. It's not as if you can easily point to a single institution in this architecture that has widespread legitimacy among the public, and that if they're given the decisive power here, there won't be any major concerns about whether that power might be abused or not. So in clarifying the Electoral Count Act and updating it, I think part of the problem is it is a very archaic statute at this point. There was a great quote from a grammarian the New York Times dug up in a story on the act, who pointed out that it took 6 hours and 2 pages of paper to diagram one, I don't know if it was one sentence or one section of the act. So part of the problem is there's just ambiguity and lack of clarity in a statute that needs to be incredibly clear, because when it makes a difference, it's got to really make a difference under tremendous partisan political pressures that will be swirling around the process. So some of what has to be done, I would call clarification. Some is revisiting some of the choices that were made initially. And then I think dealing with this institutional distrust issue, and how can we restructure the statute to recognize the pervasive distrust that's going to be there, and to provide as much security and stability and clarity for the resolution of our most important election, so that we don't have disputes about who has the authority to do what and what kind of role should they be playing. So maybe that's just an introductory kind of framing of it without getting into the specifics, but I'll be curious what Derek has to say about that.
And please, Professor Muller, love to hear from you.
Well, thank you for having me. It's a privilege to be a part of this conversation. I think about the Electoral Count Act, and really the title explains what it's supposed to be doing, right? It's the rules that Congress sets for counting electoral votes. And so, Professor Brown, as you set up the complicated system that we have from, well, before Election Day, developing these rules all the way through inauguration, there are so many stages in the process. And there's a lot of distrust, as Professor Pildes pointed out, at many stages in the process. But I think about the Electoral Count Act as some of the core things that really arose, especially in 2021, but that have been bubbling up to the surface over the last 20 years or so, as really things that involve Congress and that session itself. So I think about the fact that it only takes one member of the Senate and one member of the House of Representatives to file a written objection to a state's electoral votes, and that forces Congress to engage in 2 hours of debate about whether or not to count those votes. Between the passage of the Electoral Count Act in 1887 and the year 2000, it had been invoked exactly once to challenge one elector out of North Carolina in 1968. But beginning in 2001, there were attempted challenges to Florida's electoral votes. In 2005, there was a successful objection filed to Ohio's electoral votes. The objection wasn't sustained, but Congress had to debate for 2 years or for 2 hours about whether to sustain the objection. There were serial objections attempted in 2017 from Alabama to Wyoming. And in 2021, we saw a number of attempted objections, including successful objections filed against Arizona and Pennsylvania. And in 2005 and 2021, these are notions that members of Congress are filing objections saying we should throw out a state's electoral votes, which should be a weighty, serious matter, and yet has seemed to be more an opportunity to present on the floor of Congress opposition or relitigating the things that already occurred in the election, things that Congress really has no business doing. So as we think about that act on January 6th of counting or refusing to count, thinking about how we can make objections more difficult to file, to make them more serious and weighty to consider, And then a related concern is thinking about the role that the vice president plays on January 6th. Congress has historically believed it is the institution that counts electoral votes and that the vice president presides over the meeting. But presiding over the meeting means making some default choices as the vice president, deciding which order to present certificates or what certificates to present to Congress in the first place, or how to handle an objection. And there were a lot of conspiracies floating around in 2020 about what the vice president could or could not do, and some dubious legal precedents trying to argue what that vice president's role is. So again, thinking about that meeting itself, is there a way of clarifying the role of the vice president, ensuring that that role is limited within the constitutional authority and doesn't exceed any statutory authority, again, bringing clarity to the statute. So I think about those as a couple of things, just focusing narrowly on the meeting itself and the counting of votes that happens on January 6th.
Ask each of you, what do you think is the appropriate or the right number to wage an objection, right? I mean, I do think that most people look at this and they say one member of the House and one member of the Senate joining together is far too low. What do you think is the right number? What would you propose for a reform? Should it be limited to only those states' representatives and senators in Congress? Should it be about majorities of a state delegation? Should you allow sort of, representatives and senators from other states to object about states they have no insight into? I mean, what would you tell this bipartisan group of senators who are trying to hash out a reform? What would you like to see?
Well, I'll jump in. I think the more attempts there are to be a little bit clever or tricky to say, oh, someone from your state has to file the objection, that has historically not been the practice in Congress, and many in Congress might chafe at that notion. Some states only have one member from the House of Representatives, and so a lot rides on that decision of that member of the House. So I worry a little bit about trying to get too gimmicky in ways that might undermine its effectiveness going forward. But I think I look at the threshold of 1 and 1. But the Constitution sets a floor to say if 1/5 of the members of a chamber want to, they can request the yeas and nays to be reported in the journal. I like 1/5 for that constitutional analog. I know that the King bill that's been proposed right now is sort of a discussion bill, uses a 1/3 of each chamber as a much higher threshold to make it much more difficult. We saw over 100 members of the House interested in signing an objection. So maybe having a higher standard matters when we're talking about 435 members in the House. But the Senate has always been the sticking place, right? Many members of the House have been very willing to object. The Senate has been much more reluctant and reticent. So I think even a 1/5 threshold is going to be very high for the Senate to sustain going forward. But I'm certainly open to thinking about other thresholds.
One of the interesting ideas, I'm not endorsing this, but I just want to mention it because I think it is kind of interesting. Some people have suggested that it should be set in terms of some level of bipartisan basis for an objection. And you can see the logic behind that. I think, as Derek said, that may get a little bit complicated to really work through. The other point I want to make is deciding what the threshold for objection should be can be connected to what the legitimate grounds are that Congress has for being able to object. So if we were capable of limiting Congress's potential objections to certain very, very technical kinds of issues, which many people think is what the act actually already does, although it hasn't been honored in recent decades. But if we could limit the objections to technical issues about the qualification of the electors, for example, because there are various constitutional rules about who can be an elector, then you might not be troubled by a lower threshold. But if we're actually talking about the prospect of potentially eliminating a state's vote in the Electoral College, then I think the threshold for the objection ought to be pretty high. And, of course, it becomes arbitrary, in between the 20% that Derek mentioned or the 1/3 that is in some of the proposed legislation. There's no magic rule about where in that interval this ought to come out. But anywhere in that range is dramatically better than the situation we currently face, in which it only takes one member of the House and one member of the Senate to trigger this process that delays the electoral vote count, and can actually be used manipulatively to delay the count if there are objections to a number of states, and drag that process out for various sorts of reasons. So I think there's pretty substantial recognition in Congress that threshold needs to be raised significantly. And I don't think that will be one of the real sticking points. Of course, there'll be some discussion back and forth about exactly where it ought to fall. But I think we will see pretty widespread support for raising that threshold significantly.
So, okay, if that's what we need with Congress, we need Congress to think about restraining itself in this process. Let's kind of talk a little bit about the courts. What should the courts do, and which level of courts should play a role? I think we saw really in the 2020 election that the courts were very active at the state level prior to Election Day, making sure that a lot of the proposed and legislated upon kind of changes to the election law in those states were upheld and were appropriate given the pandemic and the kind of quick changes that were made. And then, of course, there's this problem of after the vote happens, what happens with audits or petitions or controversies. And we have this other issue of a safe harbor deadline. But then there's also the bigger issue when we look back to 2000, the 2000 election and Florida and the Supreme Court saying this isn't a precedent, but is it? So I just will ask either of you, feel free to kind of jump in and give your thoughts on who,
so
where, and when.
Before we get to the courts, which are very, very important here, I think we need to stay on Congress for a little bit longer.
Okay.
Because we haven't discussed the most important issue about Congress's role, and one of the most difficult issues that inevitably will generate different views within Congress that will have to be worked out. So the big question with Congress is, on what basis should Congress have the power to object if it's going to object? And the real question here is, does the reform statute try to have very limited criteria on which Congress could object, like a view that there's been fraud in the balloting process or that there's some illegality in the process? Or should the view be that Congress actually does not have power, should not take power, should give up whatever power it might have to second guess the returns from the state based on the voting process in the state? That will be litigated in state and federal court. But by the time the electors vote and those votes go to Congress, the big question here is, does Congress have any power to look behind those returns, to second guess them, to make judgments about the voting process? Or should Congress understand itself not to have that power at all? And that's really a very, very big consequential issue here. And I don't want us to miss that issue.
Agreed. I mean, the issue of federalism, how much federalism we entertain and we uphold, I think is absolutely central to how the Constitution was formed and how we operate as a society. So, please feel free.
Well, Derek, I was gonna give you a chance to weigh in.
Sure. No, I'll weigh. Yeah, I mean, so I think, there is precedent for Congress to go behind the returns and say, we're not going to count these votes that come from the state. And that was in 1873 involving Louisiana. But, that was we can say an extraordinary circumstance dealing with Reconstruction, the Colfax Massacre, sort of really awful events that were happening in the South in the middle of Reconstruction, suggesting there was just not legitimate elections happening in the first place. And it was an isolated instance of Congress refusing to count the votes. So the mere fact that it has done it, I think people can debate whether or not it constitutionally has the authority to do so. But we are in an era, as you set up, Professor Brown, where we have lots of litigation. We have lots of checks in the process. We have a robust confidence that when we get to the certification out of a state, the election results are what they purport to be. Right? They have a recount and an audit and a contest, whatever it might be. So I feel a lot better about any kind of statute that does bind Congress's hands to the mast, if you will, and say, if you have the results from a state, don't second guess it. There's really no reason to do so. That's not your job, Congress, anymore. And I think that's a strong preference we ought to have. And I think it's a reason why many in Congress have been uncomfortable with even considering using that power. Throwing out Florida's votes in 2000, throwing out Arizona's electoral results in 2020, those are remarkable propositions to say that the state has been so improper in the administration of its elections that the totality of the state is disenfranchised in Congress. So I'm all in favor of thinking about strengthening these provisions and trusting the state processes.
And I think we have to keep in mind Congress's limited capacity in this sort of joint session proceeding and the incredible time constraints on the process, because there's 2 weeks between when Congress first meets and when the inauguration has to take place. And if Congress is looking behind the returns from a state, then it's either going to be second guessing legal judgments that courts have made, or it's going to be getting into factual disputes about whether this happened or that happened, which will presumably also have been adjudicated in courts. But on top of that, you have to try to imagine Congress generating the fact-finding capacity and making judgments in this context in which you have each chamber kind of acting as a unit. And Congress will be acting without any real federal court oversight at that point either. So it will be kind of free to do what it wants to do. So the question is, should the door be open to Congress second guessing returns from a state, which some people believe ought to be the case out of concerns about potential manipulations in the state? Or should Congress in the statute adopt a bright line rule saying we can only object for these very, very narrow technical grounds, which really have to do with the qualifications of the electors? Now, the other thing, this segues into your initial question, though, if Congress doesn't have the power to second guess returns from the state, then we have to be very, very sure that we're going to have processes in the states that have integrity, that aren't manipulated for partisan advantage seeking reasons, and that follow the law. And so that's where I think the issue about what role should the courts have, what role do they currently have, and what role should they have under a modernized Electoral Count Act, that's how it comes in. That question, I think, comes into the picture, especially if Congress is not going to play the role it's played only since 2000. In order to persuade members of Congress who, legitimately are going to have concerns about being sure that the state process will have integrity, how can the act kind of add bulwarks into this whole structure to really try to ensure that that state result is a legitimate result according to law?
And I mean, I'll just throw out too that I do think, Derek, what you brought up about this idea of tossing out electoral votes, it really is extraordinary. And I think when you looked at sort of what the Attorney General from Texas attempted to do in other states, that was kind of equally shocking and extraordinary. Because again, this is where I think there is this question of, are the states sort of in control of their own elections? And do the state courts and then eventually the feds preside over that process? Or are we going to say that essentially anyone from any part of the republic can decide to throw out somebody else's votes? And I mean, that is quite extraordinary. So Derek, maybe you could just share a little bit about your thoughts about the courts and what their role is and which level of court should play a role.
Sure. Yeah, I think the system worked remarkably well in 2020, right? When we think about judicial review, and I'm speaking specifically after the election. I know there were a lot of pandemic-fueled challenges before the election, a lot of consternation about that. But I'm thinking about the state procedures in place to deal with the canvassing and the recount, the audits that occurred, and by audits, I mean things under statute, like in Georgia, and any contests that might have been filed. At the state and federal level, a remarkable consistency to sort of trust the process. And I think everything that ended up in Congress, those final results, I think accurately reflected the totals pursuant to law in the states. So whenever we're thinking about, do we need a different role for the courts or a new role for the courts or an additional cause of action in the states, I'm always thinking, well, what's the problem we're trying to solve? What's the risk of that occurring, historically or in the future? Are the existing mechanisms adequate or inadequate? And if they're inadequate, and we create a new cause of action, what does that look like? So as I walk through those things, I look back, I said, the system has worked quite well. Executives sent their certificates onto Congress in all 50 states. The canvassing boards all certified their election results. If they hadn't, there are opportunities to file writs of mandamus in state courts to compel them to finish their clear ministerial obligations. Now, there are risks going forward, and I hope Professor Pildes will talk about some of those risks to say maybe we're thinking about, boy, we're worried about rogue governors or rogue legislatures or somebody else in the process mudding the waters after the election to cast doubt on the results and send Congress something that isn't the true result. But I think long and hard about the risk of those things happening and whether or not existing mechanisms are able to capture them. Because again, I look to our recent precedent, and it seemed to have worked quite well. So I'm thinking about what are the interventions that would be required moving forward.
Yeah, so I'm more concerned than those comments from Derek might suggest or imply. I think what happened in 2020 is many more actors became aware of potential points of vulnerability in the system. And many more partisanly oriented figures have started running for important offices in the election administrative structure, whether it's Secretary of State positions or local county canvassing boards. And I should just say here, to put this in some larger perspective, we are the only major democracy, as far as I'm aware, that has partisan elected officials administering its elections. In most democracies, there are independent professional election administrative institutions that play this role. We have always been resistant to that in the United States. To a large extent, we've relied on entities that have partisans from both sides that can check each other in the process. But we have left this in the hands of elected officials. Secretaries of state are elected typically. Many of these county canvassing boards are elected. So that's a larger context in which these issues or concerns arise. We've also seen now state legislatures making noises about playing more of a role in the in overseeing the vote counting process. We don't know if any of those bills will actually end up getting enacted. And so I think that 2020 opened a lot of people's eyes to the way the system works, and not always to good result. And so I do think I agree with Derek that the system actually worked extraordinarily well in 2020, especially under very difficult conditions in the vote, after the voting had taken place and all the things that happened, at that stage. But I think we have to look at things with a much more skeptical eye, or a much more cautious eye, and to try to, build bulwarks, as I say, against various possibilities that I think we didn't really think much about before recent years. We don't know if these threats will materialize, but I think they're realistic enough to be concerned about, that I do want to not stand pat. Now, there are lots of complexities here when we start talking about the role of federal courts. Federal courts already have a role in overseeing the election process, as do state courts. There are federal constitutional doctrines. Bush v. Gore is the most prominent example, but it's not the only example. Federal courts can be brought in the vote counting process if people think things have gone awry, if the state process is being manipulated in a way that doesn't treat votes equally. For example, that would violate Bush v. Gore, and you could go to federal court if necessary to challenge that. But I think the last act in the process is the certification decision. And it may well be that federal courts already can be turned to review the certification decision if there's an allegation that it was based on an unconstitutional, that it is unconstitutional, the certification decision itself, because, for example, it reflects arbitrary treatment of voters or of the same kind of ballots. Some are thrown out and some are kept in, but they're actually exactly the same. But to provide more assurance about that, I would like to see an Electoral Count Act reform that sort of somewhat more expressly gives the federal courts the power to review a certification decision if one of the campaigns argues that certification is unconstitutional or violates federal law in some other way. And I think that would be the final step in really building a secure structure, or as secure a structure as we can. And then I would have more confidence in Congress not being in a position to second guess returns from the state, but only to have this limited role of objecting if there's some problem in the qualifications of the electors themselves.
Okay, so we have a lot of questions, but before we get to the questions from our audience, I think what I just want to clarify, because we just haven't said it, but I think both of you are in agreement that the vice presidential, the vice president's role needs to be more ministerial, needs to be more kind of, a formal process that is specified, but doesn't give that individual a great deal of agency in what they are doing. Is that fair? And do you think that there is a need for something else, like a constitutional amendment that would in fact move the vice president out of that role?
Yeah, I mean, I think it's a great proposal to put the Chief Justice of the Supreme Court or somebody else in charge of that ministerial role. But, the Constitution says it's the vice president who opens the certificates in that joint session. And even if you're reading the text of the 12th Amendment, it's in the passive voice about who counts the votes. The votes shall then be counted. Again, I think the better historical argument and legal argument, given the context in which the 12th Amendment arose, to Congress is the one that counts the votes, but there's still, the meeting's got to get started somehow in Congress, right? Somebody's got to be the first mover. And for the most part, the vice president has dutifully, and it has always been the vice president. It's technically the president of the Senate. And when there's been a vacancy in the office of vice president, right, that's President pro tempore of the Senate who presides over that meeting. So it could be, I suppose, right now, Senator Leahy who could preside over it, or maybe in a couple of years it'd be Senator Grassley. We'll see. You could have some roles like that, but there's still going to be some actor who's sort of moving the meeting along and sort of proceeding ministerially with this task of opening the envelopes and handing them over to the tellers. You referenced sort of at the opening about the states that had some alternative slates of electors submitted to Congress. Vice President Pence did not hand those off to Congress. No one in Congress seemed interested in counting them. So there has been this sort of reliable notion since 1887, when the Electoral Count Act was enacted, with one exception in Hawaii in 1960. There's one set of votes. We kind of all know what they are. Congress is going to get them. We count them and we move on. But undoubtedly, to Professor Pildes' earlier point, people have been pressing on some of the weak spots and questioning some of these issues. And so maybe some additional clarity would be useful going forward.
And there's a subtle issue here that's not talked about in these discussions, at least in the larger kind of public domain, which is, given that the vice president is the presiding officer or any presiding officer, and that person may have to make rulings. Hopefully they're procedural rulings, but they could be consequential. Normally in a legislative body, the majority would have the power to overrule the presiding officer's ruling. But in the joint session, we're in this very odd situation where you have the House and the Senate, and they don't act as one body. So you actually have two bodies. And so if there's a ruling from the chair, right now it would take a majority of the House and a majority of the Senate to overrule that ruling. Now that's a really high barrier. And especially if we have divided government, that's can be a very difficult situation. It might be worth thinking about whether if a single House votes to overrule the chair, that vote should control, because the argument would be, the Senate and the House are more representative bodies than the single actor of the vice president. And the vice president can be directly self-interested in the proceedings if the vice president is one of the candidates on the ballot. So that's a subtle issue, but I think it's not inconsequential when we talk about the vice president's role, because you need to ask, well, what is the check on that role? And if the check is going to be a majority overruling the vice president, should it require both chambers or only one in order to be able to do that?
Okay, so I'm going to ask you quickly, give me your top 3 things you want to see in the electoral reform, like Electoral Count Reform Act. What are the top 3 things you want to make sure that everyone is addressing? And then I'm going to move to questions.
Well, I sort of led with a couple of them, but briefly, I think about the things that are the lowest hanging fruit and the things that are going to be easiest for Congress to coalesce around. So first, that's raising the threshold required for objections when counting votes in Congress. Second, that includes limiting the role of the vice president, or clarifying the limited role of the vice president, including perhaps, as Professor Pildes indicated, one House of Congress being able to overturn a ruling from the vice president, a procedural ruling. And then third, I think simply updating and clarifying the language to use 21st century terminology instead of 19th century, how we handle certificates of appointment, not lengthy run-on sentences and so on, I think would go a long way to prevent us from exploiting ambiguities and sowing doubt in the election in the future.
I almost feel a little bit like Sophie's Choice here. I don't want to throw anything important to the side. But I would say off the cuff, first, setting up the rules in the statute so that it's clear where the authority of the state is to certify the outcome, the final authority, through rules set up in advance, and therefore kind of making it clear which slate of electors Congress is supposed to count. That would help eliminate, hopefully, the situation of 2 different slates potentially coming in from a state. So that would be one thing, clarifying the structure in the state through the statute, and so that Congress has clear rules about which certificate is the true certificate. The second is I would like to see Congress's role defined and narrowed down very substantially. And then the third, as I've said, is clarifying the federal court role here, particularly to have the ability, which the courts may have already, to review the certification, to provide that last bit of insurance that the process will comply with the law, as much as we can design a system to do that.
That's great. Thank you for that. So we have a couple process questions, and then we have some rabbit hole questions. I think we'll start with the process because it would be relatively easy. But Russell Katrubi asks, what is the process to change the objection thresholds, and does it require a new amendment?
So the objection threshold is just a matter of congressional rule. So prior to the Electoral Count Act, actually only one person needed to object. Anyone, anywhere could object during the joint session, and then they would go consider that. So Congress already updated it in 1887 to require one member of the House and one member of the Senate. So if they want to pass a new ECA that raises that threshold to 1/5, 1/3, whatever threshold they want, they can do that by statute, as much as they handle other rules like cloture motions for filibuster and the like by internal rules of Congress.
Okay, and then what I want to ask is actually from Al Vanderklip, if there is an Electoral Count Act and reform bill, would it be appropriate to try to incorporate some legal or behavioral guardrails for partisan and elected officials, either at the state level, or I think you've each suggested that Congress should essentially restrain itself.
Yeah, so I'm not exactly sure what Al is getting at, but I'll take a couple stabs at this. The first is, if we're talking about protecting election administrators from the coercion, the harassment, the intimidation that now is somewhat routine. One of the most unfortunate things that's happened in the aftermath of 2020 is election officials, many of whom are volunteers at the lower levels in the system, all the way up to the Secretary of State level, have been suffering from threats to themselves, their families, efforts to pressure them, and building in federal protections against that, including making it a crime, for example, is something that is being talked about as part of Electoral Count Act reform, and I think would be desirable. The second stab at this, I guess, is I'm not quite sure if the question is asking about something further. The complexity here is that elections are administered by state officials. We don't have a federal election administrative system. And so even though they're administering federal elections, there are constitutional issues about how deeply into that process Congress can get. And I don't know exactly what kind of behavioral guardrails the question has in mind, but I think there are those kinds of federalism issues that would be part of the picture. But certainly it can be made a federal crime, to tamper with ballots. It is already. And things like that, if that's part of what the question has in mind.
Yeah, I mean, I think that Jeffrey Davis also says, might there be any felony or criminal consequences for state legislators, and I assume other officials at the state level who attempt to overturn the state's voting. And I do think, as you've suggested, there are, issues about how far the federal government can go toward controlling those individuals.
I think you referenced earlier the notion of thinking about when we hold election day and the timing of elections. And one of the things Professor Pildes mentioned in his top 3 choices was thinking about rules in advance of the election. And I think one of the things that was trying to be exploited this election was legislators stepping in saying, well, we hold a residual authority to take action now sometime well after election day, and suggesting maybe inserting themselves into the process to choose their own slates of electors, things like that. So I do think there are opportunities. We want them prospectively, and we want to think about setting these timing rules to tell legislatures, your laws have to be on the books well before election day. Congress sets the time for choosing the electors. It has chosen this day, and we're going to adhere to rules that are set in place well before then. You can't show up at the 11th hour and try to change or maybe the 13th hour and change those results sometime after the process has already been playing out.
So, and this is one of these interesting issues that the federal law already deals with this issue. But because some uncertainty has been generated about it, I think it would be worthwhile for the Electoral Count Act to say even more explicitly than it already does, or really it's the Presidential Election Day Act that says this, but Congress says the electors have to be appointed on a single day, that Tuesday in November. And that means electors cannot be appointed after that day. And that's already the law. But because there has been this discussion now that started in some places about legislators saying, well, we can reclaim this authority at any time. That's not true after Election Day. They exercise that authority in advance of the election, but they can't reclaim it once the election has taken place. They can't decide, we want to appoint the electors now, and it's different from the result in the popular vote. And that's what Derek was saying. That is already federal law. But if we add a sentence to the statute to make that even more explicit, that would be a good clarification.
Yeah, there has been, though, some ambiguity about, right, what if there's a natural disaster and there is a failed vote on Election Day, and should the state legislature have the authority to kind of reclaim that and make sure that the state doesn't lose its opportunity to actually submit electoral votes. I mean, I think that's where this ambiguity comes from.
So this is a different provision that I've been worried about for quite a while. And I do think the Electoral Count Act reform ought to really clarify this provision. So in current law, it does say in the statute going back to the 1840s, essentially that if the election has failed in a state, the legislature can then appoint the electors. Now, what does a failed election mean? As you say, when this was passed, it was designed for a natural disaster that would make it impossible to hold the election or something like that. But because the statute doesn't specify or define what a failed election is, you can imagine legislatures now in the culture that we're in saying, well, there was this level of fraud, there were these illegalities, therefore the election failed, and we are going to appoint the electors. Now, that's not at all what that provision is meant to do, but given that it's not defined, it's dangerous. And so I do think that this is one of the things Congress ought to address, make it clear. By the way, this power has never been exercised. We've never actually had a situation where the election has failed due to any of these natural disaster type circumstances you can imagine. But if we're going to keep this provision as a sort of a fail-safe for really extraordinary circumstances, I do think Congress has to really narrow down and be very specific about the extremely limited circumstances in which that legislative power to appoint can be triggered.
So now a couple really sort of big high-level questions. The first one comes from Jim Reiser, who asks, is the Electoral College even needed today? And then along with that, he also suggests and questions, should there really be 50 different state laws, or 51 if you include the District of Columbia, state laws on the books that determine who votes, how voting is done, and does that create some due process or equal protection issues? And then I think the last big question that I'm going to just throw out there is one that Stephen Scharfman moved, which was, is there a possibility of creating a nonpartisan election reform administration? So I think my question for you is, moving away from the Electoral Count Act and just these narrow reforms, what would you like to see to our larger system if it were possible?
That's a weighty question, let me say. I mean, I think, when we talk about the Electoral College, it's fraught with many different views and many different challenges to think about its applicability today. But again, sort of opening with one of the points you raised, Professor Brown, thinking about Texas, challenging what was happening in Pennsylvania and Georgia and trying to sue them directly in the United States Supreme Court to say, hey, what you did in your states was improper. You know, there's an advantage when the Supreme Court throws that case out to say, Texas, you don't have any business with how Georgia and Pennsylvania run their elections. And so federalism has sort of its vices in the sense that the state elections look very different. Different candidates are on the ballot, different opportunities to vote, despite the fact that in theory, we're all voting for the president, even though it's technically the presidential electors. But, you know, it does have these virtues, which is it decentralizes the process in a way to avoid some of the harder questions that might arise of states battling with one another without getting into essentially a truly national federal election administration system, one that would provide consistent administration of elections from Alaska to Florida, from Maine to Hawaii, similar procedures across the country. And maybe that's something to think about, but I think that's a really big experiment to talk about in the United States, to think about changing our election system to look more like Canada or a nation where you're dealing with the federal elections at the federal level and the state elections at the local level. So I think it's a really interesting conversation to move forward, but I think there are so many components that people don't think about, or they immediately want to say, well, we can't do that, or maybe it's just easy to have a national popular vote. I think about all the amazing wrinkles as we contemplate those systems moving forward. But the long and short of it is, I think it really requires a constitutional amendment before we do it. So that's a heavy lift in its own right.
Yeah, so I'll start with the question about independent election administration. So I've already kind of indicated that I think that would be a good institutional direction to head. You could have a tiny bit of optimism about that, because what we've seen with the redistricting context is that over the last decade or so, when voters have the opportunity to vote through constitutional amendments, initiative processes in the states, a number of states have now moved toward or have adopted independent redistricting commissions of one sort or another. That wasn't true a decade ago. There were some, but there's been significant adoption recently. Is that a sign voters would be open to independent election administrative institutions? I don't know, probably not likely, but that would be a direction I'd like to see things go. One thing about the Electoral College that I think is worth pointing out in terms of reform dynamics, the winner-take-all feature is not something the Constitution requires. And over time, historically, many states have actually wanted to go to what we call districted elections, where the electors would be elected from the congressional districts and two statewide. But the problem is that it's a collective action issue. No state, take a state like Florida, which has tremendous weight in the Electoral College under winner take all, but if relatively closely divided state, if it went to districted elections, it would have a lot less influence. Now, if every state would do that, that might be fine from Florida's perspective, but it's not going to give that power up without every other state doing it, or without Illinois doing it, or New York. And so even though there historically has been a lot of interest in making a shift like that, or going to proportional allocation of the electors, as you suggested, you have to get all the states to agree to do it. And if you take the view that the Constitution does not permit Congress to step in on those issues, which would be the standard view, then there's no way to solve this collective action problem. So that's not hardwired into the Electoral College itself. It's the winner take all rule. And I think it's just kind of worth highlighting that.
Yeah, I'll just say it's also worth highlighting that it was Thomas Jefferson who laid out that logic to then Governor James Monroe in a letter in 1800 about why Virginia should move to winner take all. And it was because he knew he wasn't going to get any votes from Massachusetts because they had moved to winner take all. And he, of course, did not want Virginia to give John Adams any ballots as well.
Right.
So these are old political problems, but they always end up back at the surface. And I just want to take this last 20 seconds of our day and say thank you again so much for joining us. Thank you to the Bipartisan Policy Center. I learned a lot. I'm really fascinated by each of your writings on this. I hope for those of you who are interested in this, you will continue to read both scholars' work at Just Security and other election law blogs. So thank you again. Thank you, Bipartisan Policy Center.